The Center for Leadership and American Principles at Jacksonville State University presents the Tocqueville Lecture Series.
In this installment of the Tocqueville Lecture Series, we engage in civic discourse with Dr. Paul Collins of the University of Massachusetts Amherst and Dr. Ryan Black of Michigan State University to discuss if the Supreme Court requires institutional reforms or can maintain its current structure to achieve the goals of the U.S. Constitution.
The Tocqueville Lecture Series is made possible through grant funding from the National Endowment for the Humanities, the U.S. Department of Education, and the Jack Miller Center.
Paul M. Collins, Jr. is professor of legal studies and political science at the University of Massachusetts Amherst. Collins is the author of 4 books and dozens of journal articles on American law and politics, and his research has been funded by the Dirksen Congressional Center and the National Science Foundation. His research and commentary have appeared in popular media outlets, including CNN, the New York Times, National Public Radio, USA Today, the Wall Street Journal, and the Washington Post. Collins has also consulted with members of the United States Senate on Supreme Court nominations and legislation, as well as interest groups on their litigation strategies. His research focuses on understanding bias and inequality in the legal system, the selection and work of judges, social movement litigation, and how people experience the law. Please join me in welcoming Dr. Collins to the podium.
Thank you very much, Ben, for that very, very warm introduction. And thank you all for joining us here. I'm here tonight to make an argument for the reform of the United States Supreme Court. And I just want to start off by saying part of the reason why I'm making this argument is because I care deeply about the American Supreme Court and I care deeply about the health of American democracy. And from my standpoint, as a scholar of the United States Supreme Court, I think we're either in the territory that the court is a broken institution, or we're very close to being in the territory that the court is a broken institution. I'm going to make my argument starting by identifying what the problem is as I see it. I want to note that there are other issues facing the United States Supreme Court that I'm not going to discuss, but hopefully if those issues are of interest to you, we'll have an opportunity to talk about them during the question and answer session. So as I see it, the problem with the United States Supreme Court really involves 3 interrelated things. First of all, Americans' confidence in the Supreme Court is sitting around all-time lows, and it shows no signs of improvement. Secondly, the American public believes the Supreme Court is too ideological and, more specifically, too conservative. And then finally, the justices are making decisions that violate perhaps the most sacred norm of judicial decision-making, which is adherence to precedent. So I want to talk about each of these issues in a little bit more depth. So we're in a unique moment in American political history in that public support for the Supreme Court is sitting at or near all-time lows, and this is filtering down to public attitudes about the legal system more generally, which is to say that attitudes about the Supreme Court, our most august judicial institution, often relate to how people think about lower court judges and how people think about other actors in the legal system. And we tend to think that legitimacy in this context matters quite a bit. For example, the Supreme Court doesn't have the purse or the sword, meaning that it can't compel us to follow its decisions through financing those decisions, or there aren't police running around the Supreme Court police running around the country saying you have to abide by a Supreme Court decision. And so what this means is that the Supreme Court gets a lot of its legitimacy from you and me, from the citizenry, and we bestow legitimacy upon it. And the Supreme Court tends to be in a better position in terms of willingness to follow the court's decisions when Americans choose to bestow that legitimacy upon it. Instead, the era that we're in now, with relatively low public esteem for the Supreme Court, has resulted in the public defiance of lots of Supreme Court decisions and lower court decisions for that matter, which isn't something that we historically see. I also want to be clear that historically, Supreme Court support by the public, it kind of ebbs and flows, right? The Supreme Court's going to make the occasional unpopular decision. But what typically happens is that support for the Supreme Court comes back up, right? Over time, it's pretty stable. But as you can see from this graph, it's not coming back up, right? Public support for the Supreme Court is sitting at all-time lows, and we don't really see a lot of reason for why it's going to increase anytime soon. This is related, perhaps caused, by ideological extremism by Supreme Court justices. And I want to be clear that the Supreme Court has always been a political institution, right? Anytime you have an institution in which the president, who's elected, and the Senate, who are elected, are going to be the key players in picking judges, Supreme Court justices in this context, politics are going to play a role in the Supreme Court. But what's changed recently is that the Supreme Court has become an increasingly partisan institution. And you can see that in this first graph to my left, right? This is the first time in American history where we can cleanly sort Supreme Court justices and predict their voting behavior on the basis of the partisanship of the president who appointed them. This is not a historical fact. This is a very recent phenomenon. And the second graph shows that the public is very much aware of this. And more than 40%, a plurality of Americans, think the Supreme Court is too conservative. Only about, put it in some context, only about 35% of Americans think that the Supreme Court hits the right ideological balance. This ideological extremism has also played out in an indifference for standard rules and norms of judicial decision making. And in particular, the Supreme Court seems to be abandoning its longstanding principle of deference to precedent in favor of enacting an ideological legal agenda. We see this play out in areas like reproductive freedom, in presidential power, in religious establishment, in business regulation. And precedent is really important. This idea that courts are supposed to respect previous decisions, because respecting precedent, or the norm of stare decisis, it provides predictability in law. It provides consistency in law. And everyday people like you and me, we have expectations about what our constitutional rights and liberties are. And we anticipate that we're going to enjoy those rights of liberties for pretty long periods of time. But instead, we currently find ourselves in a position where we might wake up tomorrow and find out that a constitutional right we enjoyed today is no longer there. So what do we do about this? My suggestions are not very modest, as you'll see shortly. Instead, I'm thinking outside the box here. And what I propose is a three-part solution. And it's my belief that the solution works best if all three parts are implemented, okay? And I want to be clear that one of the most important things here is moving forward with Supreme Court reform, because that alone sends a signal to the justices that there's something wrong with this institution. So my three parts are to expand the size of the Supreme Court, to introduce staggered fixed terms, and to have the justices sit in smaller panels. While each of these proposals have strengths on their own, cumulatively, I think they do more than each individual part alone. So let me start with court expansion. So the idea of expanding the size of the Supreme Court is really put into place to address the ideological extremism that's happening on the Supreme Court. And so if you expand the size of the Supreme Court, it can at least provide some ideological diversity to the Supreme Court, if not actually moderating the Supreme Court. It also has a side benefit that would allow the court to hear more cases. And there's another interesting phenomenon that's going on at the Supreme Court, that they're hearing the fewest amount of cases that they have really in the modern era. It's about 55-ish cases a term, which is a really, really low number. If you looked at that in the early 1980s, that number would be in the 200s. And so court expansion, along with panel assignment, which I'll get to in a sec, will allow the court to hear more cases. I also suggest introducing staggered 18-year terms, although I'd be happy to talk about other lengths. The key is that the length of term be relatively large, think 15 or more years, and it also in some ways needs to be tied to the exact size of the Supreme Court. So I'd be more than happy to move that depending on agreement with what the right size of the Supreme Court is. Staggered fixed terms have a few benefits. One of them is that they more closely tie the justices to the American people, helping ensure that, in general, the justices kind of reflect the views of the public, which is to say, we don't end up with justices on the Supreme Court who have these very ideological extreme views, whether that means they're on the ideological left or the ideological right. I also see a problem with the way that the Supreme Court process has been playing out. And introducing staggered 18-year terms will take some of the heat off the confirmation process, making it less confrontational, making it less ideological. In other words, if we know, for example, that a president is going to appoint a Supreme Court justice every 2 years, when a seat opens up on the Supreme Court, it no longer seems like the sky is falling, right? Which seems to be how I would describe most Supreme Court appointments over the last decade or so. This regularity has other benefits, especially in terms of moderating presidents and getting moderation through regular appointments. And so just consider the fact that current seats on the Supreme Court in many ways open in a somewhat haphazard way. And so you have, for example, President Trump in his first term gets 3 Supreme Court justices, Jimmy Carter in his 4-year term getting 0, right? And that has to do with largely idiosyncratic factors having to do with when justices retire or a little bit less pleasant, their health, right? A lot of them die while they're on the bench. This particular proposal is not super radical. About 3/4 of Americans support the idea of term limiting Supreme Court justices. My most radical proposal is the idea of moving away from having the Supreme Court sitting as a body of 9 justices and instead having them sit in relatively smaller, think 3 to 5 justices, random panels. And if your goal is to moderate the Supreme Court, moving it away from ideologically extreme decision making, I would argue this is probably the most important of the proposals. And the reason for this is that one of the features of the Supreme Court that enables the justices to make such strongly ideological decisions is that they don't have a fear of reversal, which is to say, there isn't a higher court above the Supreme Court that they look to and say, oh, I better moderate or that court might reverse me. But if you had them sit in smaller panels, each panel could potentially reverse the other panel. It would be another case. It could take a period of time. But the notion is that if you have a panel, they might think to the future and say, well, if we had a different group of judges hearing a very similar case, they might reach a different conclusion. And so that's going to compel some level of moderation. It's probably going to put respect for precedent back on the agenda as a really important feature of American law. If they moderate, I think that they will view the public will view their decisions as more legitimate, because we won't see this sort of these wild swings, these decisions that we currently get through ideological decision making on the Supreme Court. As I mentioned, another side benefit of this is that if you take say a 13 or 15 member Supreme Court and have it sit in smaller panels of 3 or 5 judges, they'd also be allowed to hear more cases without much of a problem. How would you do this? I want to be clear. I'm primarily here to argue that we should be talking about these things. I don't think that Congress is necessarily going to pass these reforms anytime soon. I'm a realist, but there's interesting ways of thinking about how it could happen. okay? Expanding the size of the court, no problem. Congress can do that. The number 9 is, there's nothing magic about it. The size of the Supreme Court has varied from 6 to 10 justices throughout American history. And the reason is at 9, it's at 9 is because of a unique point in time where we had 9 circuits in America, and we decided we'd fix the size of the Supreme Court at 9 justices, and each justice would oversee a circuit. Today, we have 13 circuits, but we still have 9 justices. So they haven't followed that vision of mapping each justice, the size of the Supreme Court, to the number of circuits. Instead, some justices oversee a couple circuits, but there's no doubt that Congress can change the size of the Supreme Court, as they've done many times throughout American history. The introduction of staggered fixed terms is a more debatable proposition. We know for sure that it could be done through a constitutional amendment. I happen to believe that it could also be done through an act of Congress, but I will note that this is up for debate. And so in my mind, what that act of Congress would look like is an act that allows Supreme Court justices to serve, say, for 18 years, and then they would move into a type of semi-retirement called senior status, where they would still enjoy having their title as a Supreme Court justice, but they wouldn't work as much. This is actually what we do with lower federal court judges, and some Supreme Court justices actually have gone on to senior status. So the question is, the legal conundrum is whether or not life tenure as it pertains to Supreme Court justices means as a fully functioning member of the United States Supreme Court, or it could be interpreted as moving into a form of semi-retirement and retaining the title. So it's uncharted legal territory. I happen to think there's a pretty strong argument that it could be done through typical congressional legislation. In terms of having the justices sit in smaller panels, this is very much in the providence of Congress. Congress already does this with respect to the United States Court of Appeals, who sit in smaller panels. And so it's certainly within the power of Congress to change the way the Supreme Court functions and have it sit not as a body of 9 individual justices sitting as a group of 9. They could sit in 3, 5, whatever numbers Congress might be interested in. I appreciate the opportunity to share my thoughts with you. I'm looking forward to the debate with Professor Black. And as I said at the beginning, I'm bringing these issues to your attention because I really do care about the Supreme Court. I really do care about the health of American democracy. And I'm hoping that reforms like this will more closely achieve the ideal of equal justice under law. Thank you very much.
Ryan C. Black is professor of political science at Michigan State University and a faculty affiliate with the MSU College of Law. His research focuses on Supreme Court decision-making. He has published 5 books and more than 60 articles or chapters in a variety of scholarly outlets. His research has won Best Article and Best Book awards from the American Political Science Association, receiving funding from the National Science Foundation, and attracted coverage by national media outlets, including National Public Radio yesterday. He is currently working on projects related to the Supreme Court's private conference meetings and the potential impact on public opinion of allowing television cameras into the courtroom during the Supreme Court's oral argument. Please join me in welcoming Dr. Black to the podium.
Thank you very much, Ben, and for inviting us here to a spectacular event, Paul for being a good sparring partner, and you all for being here to have a bit of a chat. Paul raised some really interesting ideas, and I look forward to the chance to engage with those and engage with you during the Q&A. What I'm going to do in the minutes ahead, however, is to try to lay out more of a position for why leaving the Supreme Court alone and its current state is not just a good idea, but probably the right idea. In support of that, I'm going to try to make 3 arguments to you. First, I'd like to make the claim that while we have a large level of controversy going on in the Supreme Court, the court has been a controversial institution essentially since its birth. And that saying that there's controversy that exists, saying that there's disagreement that exists, is a necessary but not sufficient condition to say that we have a crisis going on. Secondly, to the extent that you do believe that there is a problem, I think that the system that we have at present has adequate safeguards that allow us to weather that storm and previous storms that have existed as well. And then finally, I'll make the point that I think ultimately, while the reforms that Paul has suggested here are very, very interesting, they're very thought-provoking, they're not getting at the root cause. And so they're absolutely wonderful things to think about and to consider, but they, to the extent that we are in uncharted territory, if that's something that you believe, they're not going to get at that root cause, which is ultimately going to be polarization. All right, so let's start with this first idea here that the controversy that we're experiencing right now is not at crisis levels. So Paul starts by showing a very informative figure here that indicates the level of approval for the Supreme Court has gone down and has gone down across time. There are two layers to this that I want to add, two layers of peeling back the onion. First of all, it's not the case that we don't know what's going on behind the scenes to explain why approval has gone down. And so one trend that we have noticed that is existed and has existed for decades now, by the way, is the idea that attitudes towards the Supreme Court, approval towards the Supreme Court, is polarized. Knowing whether someone is a Republican versus knowing that they're a Democrat gives us tremendous predictive power at guessing whether they're going to approve or disapprove of the Supreme Court. So polarization is going to be sort of a broader theme I'll come back to when I talk about the fixes. But not only do we know that, we also know that it's not just polarization, but it's also how we react to the actions taken by the Supreme Court. In short, what we learn is that it's not just a standard attitude that we have, but rather it's an attitude about what have or have you not done for me recently. And so two nice sort of case studies illustrate this point. The first one comes in the form of the court's 2021-2022 season, when, as Paul suggested and showed with one of the screen clips, that the court overturned Roe versus Wade's decision in Dobbs. And so this was a massive event with regards to public approval, but approval was split, right? And so what happens is knowing if you are a Republican versus a Democrat tells us how you reacted to that decision. And so if you are on the Republican side, you're very, very happy with it. Your approval goes up by 29%. At the end of the court's term that year, Republican approval is around 75%. 75% approve of the work being done by the Supreme Court. That's up over when it was below 50% at the start of the court's season that year. Similarly, Republicans rise, Democrats drop off to a tune of about 23%. Now, that in of itself, if we saw that over and over and over again, would be troubling, right? If the output of the Supreme Court historically had been one direction as opposed to the other. But what the data suggests is we don't have to go back too much further into history to see where the tables were reversed and Republicans were on the losing side of the ledger. So during the court's 2014-15 season, Obergefell versus Hodges landmark decision establishes the right to marriage for same-sex couples, and that delivers a win for Democrats. And so what do? Democrats show their approval for the Supreme Court to the tune, again, of about 29%, which coincidentally or not is the same increase that we see on the Republican side for Dobbs. Similarly, Republicans respond in turn with a decrease in their level of approval towards the Supreme Court. Now, what does that tell us? It tells us that what's going on in public approval, what's going on with these questions that we are asking the public is it's polarized, and it's polarized with regards to the performance that the Supreme Court is delivering for them. Now, that's in contrast to more enduring attitudes. That's in contrast to the idea that the Supreme Court has a right to exist or that the decisions of the Supreme Court need to be followed by political actors. Thankfully, however, we do have data that let us speak to that more direct question of the authority, the lasting authority of the Supreme Court. To January of 2026, the good folks at Marquette University put into the field a polling question: if the Supreme Court rules against the president in a case, does the president have the power to ignore that ruling, or is the president required to do as the ruling says? What do the results suggest? Overwhelmingly, 82% of the respondents that were asked this question indicated that the president has to listen to the ruling of the Supreme Court. Now, you're probably thinking to yourself, okay, well, you just told us that everything is polarized. What about Republican attitudes on that? 73% of Republicans also supported the notion that when the president and the court come in conflict, that the court is the one that reigns supreme. So the general point here, to take a step back, is that we do see these fluctuations in public approval towards the Supreme Court. but they track alongside the decisions of the Supreme Court. They don't represent the enduring support towards that institution. And when we do ask that question that really tests the limits of the court's authority or tests whether disobedience of the Supreme Court is something to be tolerated, the people tell us that that's not something that they're willing to stomach at this point. And so it doesn't mean the crisis couldn't come into the future, but to say that we're in that crisis mode right now or barreling down towards that pathway seems a bit premature at this point. All right, second general point is the idea that the system that we have at present, so why aren't we in that crisis mode, right? So if the Supreme Court has been making all of these decisions, what is it about the institution that is keeping everything working reasonably well? And so Paul stole a little bit of my thunder here when he talked about the Supreme Court having neither the power of the purse nor the sword. But so this is not featured in the musical for reasons that are beyond me. But so Federalist 78, we learn that the court is this institution that has only judgment, right? Can only sort of offer its best argument for why we should do something, but it lacks the ability to enforce those decisions. And so that is a critical component to this process, right? The idea that while the court is unconnected democratically from voters, that the court still depends upon the coordination, the support of other institutions and of the public in order to maintain that reservoir of goodwill. The justices know this, which means that they are mindful of it, which means that they are the ones who are responsible for protecting that. Now, do all of the justices do it to the same degree that you might want? Probably not. There's obviously going to be variation. But overall, there's good evidence that the justices are aware of this, recognize that there are the potential limits to their authority, and then when the court seems to get on thin ice, they do things that allow them to walk back from that ice. I'll start with sort of just an anecdote from that and then kind of build in a little bit more evidence. So anecdotally, from just last month, Supreme Court holds by a vote of 6-3 on the tariffs case. If you told somebody in advance the vote was going to be 6-3, there'd probably be a knowing nod, but it's not the 6-3 that you would have expected. In particular, it's not the 6 Republican-appointed justices who are voting in favor of the president, but rather it is a coalition of Republican and Democratic-appointed justices who are crossing over, and in particular, 2 out of the 3 justices who were appointed by President Trump. Okay, nerd, so you've decided to cherry pick a case. What about, you could go and find 1 out of the 25,000 cases that support your claim. Fair enough. So then we can look at a little bit broader of our worldview to see that there is still meaningful variation, that the idea that the Republican appointees behave as a monolith is something that's simply not supported with the data that we have available to us. And so what you're looking at here with this little bar chart is the amount of voting behavior, liberal voting behavior in criminal procedure cases. So the rights of the criminally accused, the stuff that you see on the endless variants of law and order, right? So 2 things are worth noting here. First of all, it's absolutely the case that Republican appointees cast more conservative votes than they do liberal votes, right? These bars never exceed a 50%. So that's absolutely true. But the second thing that's really worth noting is that these bars aren't all of uniform height, right? So while we do get leverage at predicting whether a vote's going to be conservative or liberal based off of the party of the appointing president, that there's much more to the story than meets the eye. Particular Justice Alito, for example, you see is voting about 20% liberally compared to nearly 50% for Justice Gorsuch, and Barrett Kavanaugh are not terribly far behind. Why is that important to us? It's important because there is this wisdom on the court. There, not necessarily wisdom, but there is this variation on the court producing these different outcomes. And so the court is not marching in lockstep towards always predictable outcomes. You might say yet again, all right, so you picked one issue area. What about sort of a broader approach? And so in the sake of completeness, I went ahead and looked at that as well. So rather than looking at just the 6 justices, conservative justices on the court, and a single issue area, we can look at all 9 of the justices across all of the issue areas, the plethora of cases that the court decides in a given year. And so what you're looking at is a couple of mountains, right? So the red mountain is the justices who are appointed by a Republican president. The blue mountain is justices who are appointed by a Democratic president. Now, to be clear, the lines do not overlap, right? We see distinct peaks, which indicates that there is some separation, that Republicans behave differently as opposed to their Democratic counterparts. But what we also don't see is a tower. That is, there's a range of values that we see. We see Republican justices casting 50, 60, 70% liberal votes in some issues. Similarly, we see Democratic appointees who are casting 40%, of liberal votes in some of these issues. And so that's one important component, is that the sort of range of outcomes that we're seeing in the criminal cases is not limited only to criminal cases. The second thing I would say is that while we do have these distinct peaks, we don't have two separate islands, right? So there's overlap here, which indicates that where there's coalitions that are coming together, for example, on the tariffs case, that those sorts of coalitions are not one-off, but rather a more common component of the court's decision-making process. What that indicates is that the court is working at times towards achieving consensus and at times towards moderation in certain areas. Now, it might not be as much as you want in a given area, sure, but to say that the court is sort of behaving in this monolith belays the actual data that we have. All right, final point that I'll make here, and I'll confess immediately here that I got a little excited with the alliteration and perhaps also the hyperbole on this particular one. But the general idea here is that the proposals that Paul has suggested are incredibly interesting as a policy package, right? And so they're definitely worth considering. But ultimately, the question is whether they're going to get at the fix that that Paul and folks that are on that side of the debate want to have happen. And I don't think that's true. And the reason why I don't think that's true has to do with what are the underlying causes here. Recognize at the very top, I talked about how attitudes are polarized towards the Supreme Court. Also recognize that when we're talking about the individuals who are getting nominated to the Supreme Court, that we don't see moderates. We don't see individuals who are in the middle. The last moderate that was nominated didn't even get a Senate confirmation hearing. And so the polarization that we have in all aspects of American society are crossing over into the realm of the Supreme Court. Now, why have you been looking at Starbucks and Dunkin' Donuts? Because it shouldn't be surprising then that attitudes and the institution is polarized, because polarization is a ubiquitous aspect of life in American politics. Attitudes towards your preferred coffee brand, for example, are polarized, with Democrats preferring Starbucks and Republicans preferring Dunkin' Donuts, both individually and also looking at campaign expenditure values. Similarly, and I don't know why researchers ask this question, attitudes towards what pet would be the best president are also polarized. So Republicans think that dogs, by a tune of 5-1, would be better presidents than would be cats. Democrats much more evenly divided. Again, to be clear, I did not write that question or put that question into the field. More broadly, though, the point that I'm trying to make is that if all aspects of political life have been polarized, the problems that we have, right, the malfunctioning component, for example, of the Supreme Court confirmation process is not something that gets fixed by adding more justices to the Supreme Court. It can be done via legislation, and that's actually more of a bug as opposed to a feature. You add in some justices, and then the next Congress comes along and you've got unified government, and then they add in more justices. And pretty soon, you're at a Supreme Court that has 75 justices. And then you have to have panels. Panels aren't simply a feature, but rather a requirement. And so what's problematic about panels? Well, with panels, you have the possibility that you're going to get conflict among the law. Right now, the Supreme Court's function, the main function that it plays on a day-to-day basis, is providing uniformity in the law. The individual circuits can make their own decisions, but the Supreme Court comes in and establishes uniformity. Now we don't have one Supreme Court, but we have various flavors of the Supreme Court. And so if we're looking for respect for precedent, we're looking for even a clear understanding of precedent, adding more justices and further complicating the process isn't going to get us very far. And so all that is to say that these proposals, while being incredibly interesting, thought-provoking, and absolutely things that we should be talking about, because when we talk about them, the justices are paying attention to the types of things that we're talking about and know that they're potentially at risk, which in turn is going to potentially induce more compliant behavior on their part. They're ultimately Band-Aid solutions to the cancer problem of trying to address political polarization, which means they are probably not very likely to work at all. So again, thank you so much for being here. Thanks to Paul, thanks to Ben again. And I'm looking forward to chatting up with you all in the minutes ahead. Thanks.
I really want to know why birds weren't included in that question. I feel like as the campus that hosts, game, we need to address that. But that's for another
What
day.
type of bird? Though,
That's
right?
right.
So I mean, are you talking a
Yeah.
pigeon? Are you talking a quail?
A
A
gamecock.
Well, I mean, obviously, it'd be the gamecock.
Yeah,
when I run the survey here, that'll be what's
Yeah. But maybe a good place to start for us, besides fixing survey questions, is just starting with laying out our ideas about the court itself. And so, for both of you, what do you think the main purpose of the Supreme Court is for American popular government? What do you think its main goals, functions, ideals, aspirations are?
Yeah, I tend to think of the primary function of the Supreme Court as dispute resolution, but that means a lot of different things, right? So you mentioned like resolving conflict in how lower court judges interpret the law. It also means to the two people involved in a case. That's probably not how the Supreme Court sees its major role. But what's happened over time through that conflict resolution role that the court plays is that it's very much a policy-making institution now, right? Which comes out of the fact that its decisions set precedent and that it has the power of judicial review.
Yeah, I think, and then in addition to that, the policy-making component has been, and again, to sort of talk about polarization, it's because other institutions aren't. So I don't know that in more recent years, that sort of we need to go, or people go to the courts for policy because you can't get it through the other branches. But I think, ultimately, sort of just a textbook answer would be that final arbiter on the Constitution, interpreting the law, and since so much of the work is done by the underappreciated lower courts, when they come in conflict, coming in and offering that uniformity.
So, Paul, given that you think the main guiding principle is sort of this conflict resolution, is that the main idea behind your reforms, or the main idea behind your reforms some other principle?
Yeah, I think the main idea behind the reforms that I and others are suggesting is based more on the idea that the Supreme Court has become too ideologically extreme and has become, in many ways, untethered to mainstream America, right? That it's sort of enacting a legal agenda through the resolution of conflicts, right? Because it's getting this power, it's doing the policy making through disputes that regular people have, that it's increasingly outside of the norm, right? And so Ryan had like really interesting graphs about polarization, but missing from the graphs were independents, right? And so when you add Democrats and independents together in, say, for example, looking at public approval for the Supreme Court, that's when you start to see a majority of Americans aren't super happy with the Supreme Court. And so my reforms are more intended to moderate the Supreme Court as an institution, which has more or less been how the Supreme Court has operated throughout most of the modern era. It's a relatively new phenomenon that it's sort of enacting such an extreme agenda.
Ryan, do you agree sort of with the ideas behind Paul's wanting a reform, or do you think something differently here?
I'm a bit different, and I think that the if the issue is with the ideological extremism associated with the justices, so that's okay. So then the process that leads them to become justices is one that is problematic, right? And so it's presidents with more extreme preferences, it's members of Congress with more extreme preferences, interest groups who are providing the names and support with more extreme preferences. And so making the process with more seats, or making the process with happening more regularly, you're just running more individuals through a process that's already going to lead to those outcomes. And so I think that ultimately it's working within that system. There are these broader concerns I think that we have that just putting more people onto the court or having them rotate off the court don't get at. You'll have more extreme justices. There'll be a longer list of Federalist Society judges who are waiting in the wings, so that when the expansion occurs, that okay, those are the names that are going to go forward.
Paul, how do you think your reforms or those suggested reforms would deviate from this idea that it's just going to replicate or extend the problem?
Yeah, this would ultimately come down to the exact way of expanding the court, right? So if you're a very liberal American, you might say, make it 13 tomorrow. I'm sorry, make it 13 the next time a Democrat's in office. I misspoke. That's not really what I have in mind. I have rather like a phased in expansion of the court over a period of time in which presidents of both parties would be able to appoint justices, thereby, at a minimum, increasing ideological diversity. But I take your point very well. Increasingly, part of the problem in America is that Congress isn't doing its job. And so when you have congressional gridlock, you end up looking to make policy through other institutions. And one of those institutions is the Supreme Court. And so the court's role in this kind of polarized era has changed quite dramatically. But again, I tend to think that I have doubts about what it means to be a moderate judge. I'm not totally sure I can wrap my head around that. So in some ways, having an ideologically diverse court that sits in panels that are randomly assigned compels some level of ideological diversity that might lead to moderation.
Why should we prefer ideological diversity if, when we elect our representatives, we want some type of uniformity?
Yeah, it's a great question. So think about it this way. The Supreme Court hasn't been liberal since about the early 1970s. You could say 1969, but let's just say early 1970s for argument's sake. And estimates are that the Supreme Court will not possibly go into liberal control during the lifetime of anyone in this room, no matter how young you are. Which is to say, there's a very strong possibility that for more than a century of America, the Supreme Court will be a conservative institution. Now, if you're conservative, that may sound wonderful to you, but if you're a conservative, think about what I just said if I was telling the same story with respect to a liberal court, right? That is an exceptionally large period of time for one ideological perspective to dominate a political institution that has policy-making authority. So that's why I tend to think, right, how did that happen? It's complicated. It's a lot of, sometimes haphazardness about why one president gets to appoint a Supreme Court justice, another one doesn't. But we're there, and it seems unlikely that will change anytime soon whatsoever.
Ryan, do you think we should be aiming for some type of moderation or diversity of ideology on the court, or is some type of ideological conformity on the court just a function of American government?
I think that it's representative of the choices that people make when they vote, right? And so elections have consequences. And so that's sort of the initial response, is that the court hasn't been liberal for that long of a period of time, for a very long period of time, but also American politics has been not liberal for a pretty long period of time as well, generally. I also think then that it really does get into sort of the inside baseball-y things about how we talk about the liberalism or conservatism of the Supreme Court. And so I think that thinking about it beyond just sort of 70% or 65%, that there is a lot of variation there, that you do see significant deviations where you wouldn't expect it, and so I think that the top line part might be accurate, but I think that doesn't necessarily mean that the wheels have completely come off the car.
Yeah, you raised a really good point in your mini lecture when you were talking about how some justices might pay more attention to this than other justices, right? And so we often think about Chief Justice Roberts as perhaps caring more than anyone else about how the esteem with which the public holds the Supreme Court. And in fact, he probably switched his vote and upheld Obamacare because he cared so much. And that's great. And that's certainly, if you're like me and you think that moderation is desirable, I would say that's a step in the right direction. But it doesn't happen on all issue areas. Some issues are more important to his agenda or other justices' agendas. And when Roberts cares deeply about an issue he moves in the conservative direction, right? Like, for example, he's basically the champion of gutting the Voting Rights Act, which is mission accomplished, basically. Very close.
And doing so gradually too. I mean, doing it, but I mean, that would be more, I mean, I wouldn't call that moderation, but I would say that there's a difference between that and just flipping it immediately overnight, right? And obviously the outcome's still not desirable from that perspective, but over the course of a series of years.
But aren't we asking something different of the court than the other institutions in some way? Why should we expect the court to behave this way if we look back to the framers who say, look, this is just ambition v. ambition. We're not going to build a system for humans as they ought to be, but build a system as humans are. So are we expecting the court to behave in a way that's different than our other branches? Or are we somehow expecting that all the branches are going to reach this level of moderation? And that's the ideal or the goal of something?
So I tend to think moderation is incredibly desirable in the law because the law is in many ways based on expectations of predictability and consistency, right? The idea that the constitutional rights that you enjoy today, you have a very strong expectation that you'll enjoy those constitutional rights tomorrow and probably for the rest of your lives. And so consistency is arguably a lodestone of any functioning legal system. And so when you have disruptions to that consistency and when they can seemingly be pinned on the confirmation of new justices to the Supreme Court, the court itself looks like a very ideological and partisan institution, which is what the public is catching up to, right? The public's pretty clear on this. And so so to be direct, yeah, I think I am asking something different of the Supreme Court because it is a legal institution, and because consistency and predictability is a staple of American.
So I think I agree with you that there's that predictability component. And I think that my point would be that the justices in general know that and know that they don't have the electoral mandate that comes from free and fair elections. And so that their legitimacy is their ability to make these decisions, to overturn precedent is predicated upon at least the appearance that they're proceeding in a reasoned and measured type of approach. And again, there's we talked about earlier, we got to talk to one of your classes, and we talked that there's a lot of variation on the court about that in terms of how much they adhere to the norm of stare decisis. And you've got Justice Thomas, who essentially doesn't acknowledge it at all, and you have Chief Justice Roberts, who's much more in that camp. And so I think again that's part of the system, right? It's an institution that does not have that mandate, and so ultimately does have to proceed most of the time pretty slowly. And in that proceeding that slowly, that's when elections take place. That's when retirements take place. That's when deaths take place. And you get that cycling through of justices that bring in new views and potentially shake up the votes that are taking place. And those votes are, the individuals that come on, that's representative at least of the snapshot at that point in the point in time. It means that we probably should be talking more about Supreme Court justices as an election issue because of the ramifications. It's going to be the most lasting policy consequence that a president has. And that's something I think is not at all appreciated as much as it should be.
Well, Ryan, you mentioned some concerns that you had with these reforms. Could you maybe flesh it out a bit more for us? Like, of the reforms that Paul has brought forward, what are the concerns that you really see from these proposals?
So I think the biggest concern I think I have on the expansion side, and I think there probably are, there could be rollouts that would lessen it, but ultimately, since it does just take a simple act of Congress, it's not clear to me how this doesn't become tit for tat. And the second that you have unified government, that you have one party control of the legislature and the same party of the president, why not just add in a bunch of seats? And along the way, why not also, if you've got a panel situation going on, and so you kind of create more of like a parliamentary system where things would change very, very quickly overnight, depending on who happens to be in power. So I think that, like, from a reform perspective, that's one issue. And then the second one, I think, is really it's if there are these components that are broken, if we do think that the individuals that are getting put forward are not ideologically representative, then you're just putting more individuals through that broken process. And that doesn't strike me as being a particularly good way to conduct stuff. And then on the point about panels, it's interesting and probably necessary, right? So if you get to a Supreme Court that's double digits, they changed the shape of the bench once. I mean, they would have to probably add like a double-decker type situation in order to house all of those justices. But I'd be really concerned about the idea that so you've got a panel of 3 justices, 5 justices who make a ruling, and that's the state of the law. But it's the state of the law until another panel comes along and flips it, or until they decide they need to get together as an entire body. And so all that's really doing is creating confusion potentially, and sort of kicking the can to ultimately you're still going to have 17 justices, 19 justices, 13 probably, I think is the number you land on, that are resolving that type of issue. Packaging them together, I think, helps because there are some spots that one proposal can get at versus the other. The last thing I'll say, though, is on the term limits, the non-renewable term limits. One thing that concerns me there is that we tend to nominate justices who are younger today. I don't know that we would move away from that, but assuming that there is a preference for sort of younger justices, one concern I would have is that if a justice is serving for 15, 18 years, they're retiring at a pretty young age. And pay for Supreme Court justice is pretty great, but it's not great in relation to what the opportunity cost would be for individuals of that caliber. And the idea of revolving door lobbying going on the Supreme Court, where a justice is coming back to argue a case in front of their former colleagues, like what we see lobbying of Congress, would be really interesting from a social science perspective, but I'm not sure very good for perceptions of justice, perceptions of equality under the law, and all of those other things.
Yeah, actually, one of the potential things that could happen if you introduce lengthy, say 18-year terms of Supreme Court justices, is that it could actually open up the opportunity to have older judges appointed to the Supreme Court. So today we've more or less reached a situation that if you're basically over about 55 years old, you're too old to be a Supreme Court appointee. And that seems crazy, but what's going on is that presidents recognize that by appointing very young judges, right, usually about 50 years old, they're going to have this long-lasting imprint on the fate of the Supreme Court and American law. And with advances in modern medical technology, right, it's not at all weird to be thinking of a Supreme Court justice potentially serving for 40 years. And in fact, Clarence Thomas seems to be like shooting for something like that. And so what that means in terms of basically brass tacks is that if you're over 55, you're out. And so that means we're disqualifying these really, really qualified, folks who would be great judges because of their age. And so it could potentially address that. But I appreciate the point about the revolving door, and something would definitely have to be done to counter that.
But if the goal is consistency, aren't some of the concerns being brought up by Ryan showing that these reforms might actually reduce consistency from the court?
So I actually think the panels would lead to consistency. I think it's a feature, not a bug.
How?
So I think it would compel moderation, right? I don't think you would have a situation where panels are thinking, oh, we can just do whatever we want because the lottery system happened to end up with 5 people who are, on my side and not the other side. I think they're looking at the shadow of the future, and they're thinking, well, the next lottery system might end up with a totally, with 5 liberals instead of 5 conservatives. And so I think to maintain legitimacy, they would moderate themselves, right? But I'm assuming that they care about that, right? Which if they don't, then I'm wrong, right? I'm wrong. I'm assuming that the Supreme Court cares about its own legitimacy. And so I think it would compel moderation.
I think it also assumes that there's a grab bag of cases that are always available to revisit particular issues, right? And there are, 8,000 or 7,000 or something cert petitions that come in a year. So maybe that could be, maybe you can have the shadow of the future where, we could get reversed by by another panel at some point in time. I'm also curious, how would the case selection stuff? This is interesting.
Yeah,
So
so
like, how do you pick cases? Like,
there's a lot going on, right? So these are bold proposals, and I actually was very reluctant to get on board with court expansion because the exact reason you articulated, which is you could end up with this tit for tat, and so one party comes into power, it's 13, then it's 15, then it's 17, whatever, right? And that's why it occurred to me that tying it to panel assignment would kind of take some of the pain, some of my concerns out of that. But yeah, there would be interesting processes that would probably have to be changed with respect to. So the Supreme Court effectively gets to pick and choose the cases that it hears, and the current process is that the votes of 4 of 9 justices are enough to agree to take a case. So that would have to be revisited.
I have to check something. I have to.
Oh boy, he's got the pocket constitution.
The judicial power of the Supreme Court shall be vested in one Supreme Court.
Yeah.
So panels.
Oh, I don't have a concern about that. You're a Supreme. It's a Supreme Court that sits in panels. Yeah, I'm not overly worried about that. That's a legal bug for you.
I don't know. I just maybe. I mean, it's like it's on low on the list, but,
right.
but it's there. It's in the Constitution. One.
Yeah. Well, I think it is still one court. It just sits differently.
It has a double-decker court.
Yeah, we expand the building. Maybe
you've got the A team, you got the B team.
Well, maybe just one more question before we go to our audience here, because you guys are both top-notch scholars on the court, but you also both have engaged with the public. At this opportunity to speak to students here on our campus, to teachers who are listening, to the public. What do you think the American public generally misunderstands about the court? And how do you think that misunderstanding may affect our ability to properly evaluate the court and have expectations of the court?
So I think that perhaps the biggest misnomer with respect to the Supreme Court is the idea that there are often objectively correct answers to difficult constitutional questions. We instill this in Americans when they're pretty young by putting courts and judges on pedestals, and I don't think that's a particularly healthy way to introduce people to what judges and in particular what the Supreme Court actually does. I think a more realistic understanding that these are people that have power, these are people that have political preferences, that the law is typically not at all black and white, it's shades of gray, is a better starting point to have more serious dialogue about the role of this incredibly important institution in American democracy.
Yeah, I think I would 100% agree with Paul on that. I would say that and it gets reinforced not just from a young age, but it's also reinforced anytime a Supreme Court justice sits on a stage for a Q&A, which is that it's their job to reinforce that idea, the idea that the decisions are made on the basis of law and that their job is to simply find the law. And they'll say that it's not a trivial thing to do, but and then I think that at the same time, though, to characterize them as just legislators who are wearing plain black robes also overstates the case. And so the truth is always someplace in the middle. And so that they are political actors that are selected through a political process and have political goals, but they're also important checks that they have as well. And that does make them unique, but not for the same way that I think that the justices and that most of our textbooks would generally try to portray them as.
Wonderful. Well, I welcome questions now from our online audience in the Q&A or from our in-house audience. And so if you have a question here in-house, please raise your hand. I'll come here with a microphone.
Hey there, I'm Benjamin Blevins. I'm just a student here. In introducing terms to the Supreme Court, would it not then potentially open the door to more political lobbying and then causing a more extreme what's the word I'm looking for? Separation in the ideology between court justices, separating the two overlapping peaks more than they already are?
Yeah, that's a great question. It's so the current means by which a Supreme Court justice is appointed and confirmed is about as political and nasty a system that you could possibly come up with. So I have a hard time kind of conceptualizing like how that could get worse. One of the benefits of term limiting Supreme Court justices is actually taking some of the heat off that process, right? By which I mean when a seat opens up on the Supreme Court, and especially if it's, say, for example, a seat held by a Democratic justice and there's a Republican president in office, it's almost this sort of sky is falling moment in American politics. And that's probably not the best environment to be appointing Supreme Court justices. And so I've been an advocate for staggered 18-year terms of Supreme Court justices for a very, very long time. And that was actually the original reason. I've been advocating, we need to take heat off this process. The process is broken. It's not performing the role that it used to do. Today, I'm talking about how that also could potentially, with the other reforms, lead to some type of moderation. So I've evolved a little bit about what term limits mean. But I sort of look at the world, and I look at the world of Supreme Court appointments as more or less an indefensible process. And I will note that 10 years ago, I wrote a book defending that process. So this has been a pretty significant change in how I view the Supreme Court in the last decade or so.
I think, so the only thing I would sort of throw back on that is that the happenstance nature of an appointment is problematic, right? But all that means in a term limit situation is now it's a scheduled fight. And so now you know in advance precisely when you're going to show up in the schoolyard and get ready to throw down. And so I don't think, that genie is kind of out of that bottle, I think. And I'm not sure that having more of those bouts is going to really help anything. I think it's the stakes are still going to be just as high. It's still, well, potentially with the term limits, that maybe that takes a little of the temperature down because it's only 15 years as opposed to 25, 30, 40 years, something like that. But still, even a 15-year term limit is going to be a policy accomplishment that exceeds the president's time in office, right? It's still going to be the single most important thing that a president has the ability to do when they are in office. That doesn't change, right? And so to the extent that that is what's driving the salience and driving the need to get it right type approach, all your term limits is just sort of routinizing, it's a regularly scheduled fight as opposed to a impromptu brawl that's taking place. And so I think it's still pretty hot.
To clarify, in what I was talking about, I'm less referring to the process by which a Supreme Court justice is brought in, but rather that the candidates themselves will become more extreme in becoming more attractive to their party for whoever would be in power.
Yeah, I'm not sure that there's a reform that can prevent that. Basically, the means by which presidents are appointing judges, whether we're talking about Republican or Democratic presidents, has shifted a lot. They put a lot more effort into making sure that those folks are ideological allies and won't shift too much over time. Almost all judges shift a little bit. But they've gotten very good at it. I wouldn't know how to undo that unless you were more or less randomly elevating lower court judges.
Yeah, you'd have to do something that's more like like the Missouri plan or something, where you have, very few states actually mirror what we do in the federal government for picking judges, like both at the selection stage as well as at the whole unconditional lifetime tenure thing. But so, one approach would be to you have some sort of nominating commission that generates a list of individuals who are deemed to be of appropriate judicial temperament, whatever that means to the individuals who are on the committee, and then the president picks from that list or something along those lines. So that's all. If we're doing sort of very, very big, broad swings for the process, that would be something that could be incorporated. Maybe you're just shifting the the controversy then to that nominating commission. So who gets to pick who's on the nominating commission? But
and one of the big challenges with doing something that we would call like a merit-based system is that every Supreme Court justice is basically meritorious, right? They're setting aside their ideologies. They're an incredibly homogenous group. They, tend to go to one of two law schools. They all tend to have been United States Courts of Appeals judges. They have very similar backgrounds, right? So we sort of know what, even though there's no constitutional requirement for being a Supreme Court justice, we sort of know and can describe what a Supreme Court justice looks like. And that's something that's true of both political parties.
Hi, I'm Skylar Leith. I am a student, and mine's kind of like a two-parter question. Do you think the Supreme Court should kind of adopt or kind of add a binding code of ethics? And if so, do you think there should be, what kind of rules do you think will be needed to address the potential conflicts of interest that could arise from that?
yes, I think so. Yes, yes. I think that a binding code of ethics. So there are a number of reforms that that enjoy significant bipartisan support. So court packing or expanding the size is very much polarized. But term limits and mandatory retirement age and a binding code of ethics enjoy fairly strong bipartisan support. And it's not super clear to me why Supreme Court justices are held to a different standard than other federal lifetime appointment judges are. So I think yes, that would be my answer.
Yeah, I completely agree for the exact reasons Professor Black articulated.
But they have recusal software now.
Oh, I didn't know that.
Thank you so much. Sorry, over here. Hello. My name is Wes Bishop. I teach in the history department here at JSU. And so one thing I'm kind of curious about that isn't being discussed is why not just move to a system where the Supreme Court justices themselves are elected nationally? And I don't know the answer to this. I mean, how many state Supreme Courts already behave this way? And in a way, maybe it wouldn't solve the issue of partisanship, but it would solve the issue that it actually does reflect what people want. So, even if it's staggered, right, you have 13 seats every few years, right, people have to go to the polls and vote. Why not just do that?
Yeah, it's a great question. So most state judges on high courts are elected in some way. There's about 3 different ways that states do it. Sometimes it's a partisan election, just like a regular election. Sometimes it's a nonpartisan election, and sometimes it's a retention election where we're basically asking, should we retain this judge who served for typically a longer term? I have mixed feelings about the election of Supreme Court justices. My biggest concern is that I worry that the public doesn't pay attention to what might make for a desirable Supreme Court justice, and that turnout might be so low, which it is in judicial elections. This we know for sure, that a very small elite group of voters are actually the ones doing this election. And so that's like, when I say turnout is low in judicial elections, I mean really low. If there's a judicial election in a state and it's not simultaneous to like electing a governor or a federal election or something like that, we're talking like 10 or 15% of voters turn out to vote. Now, I'm pretty sure that a Supreme Court election would be more than that, but I have serious reservations about who would actually be doing the voting.
I'm actually writing a paper right now. I should be writing a paper right now that looks at the empirical consequences if you were to go back and rerun history with that. So you can email me or something in like about 3 weeks time, and I can have like at least the counterfactual answer to it if everything goes according to plan. I'm very, very excited about it. But I think that I'm not as worried about the turnout side of things. I think that you'd bring a level of importance to elections that would. You can. There's also just ways of designing it so that they occur in presidential election years, for example, which would be the easiest way to ensure that you've got the highest possible levels of turnout. it's probably the biggest swing that there is, right? So I mean, in terms of parts of the Constitution that would need to be tweaked in order to make that possible. But you would take out that, my argument that I was making up there was that there's this indirect effect, right? That you have public opinion, and ultimately justices need to be aware of public opinion and not stray too far from it, and keep themselves in check that way. And so you'd cut out the middleman from that equation. So it's an interesting idea. I mean, it's one that's just so big and kind of big of a swing that's kind of hard for me to wrap my feeble brain around. But that's why I just try to what would it look like if it were to happen? Not is it good or is it bad? But it's very, very, very interesting. So.
Hi, my name's Alexis Page. I work here at JSU. So as we know, the ideological dispersion of the Supreme Court favors conservatives with a 6-3 majority among justices. And referring back to the graph in Dr. Collins' PowerPoint, it would appear that the ideological leanings are also a bit more extreme among conservative justices. Meanwhile, the ideological split in the U.S. has about 45% of voters identifying as Democrat or Democrat-leaning and 46% as Republican or Republican-leaning. With this in mind, we know that a more balanced court would better reflect the beliefs of the American people. My question for you is, should we strive for better representation of ideological leanings of voters? If not, what should we seek instead?
Yeah, it's a great question. I think it's desirable. I think it's useful to have the Supreme Court more closely reflect the preferences of the voters. Now, I want to be clear. That doesn't mean beholden to voters, right? Then we're in the territory of elections, which is a different conversation entirely. But the way I often try to articulate it is that one of the things we're trying to do when we're confirming a Supreme Court justice and we're having those very public confirmation hearings in the United States Senate Judiciary Committee is figuring out if they fit within the constitutional mainstream. And that doesn't mean that, they have to be exactly in the middle of that mainstream, but there are certain positions that are accepted as part of that mainstream, which generally reflect sort of how the public in the era in which they're being confirmed would think about the Constitution. That's part of the impetus for why I think term limiting Supreme Court justices works, because when you have a justice who serves, say, for example, 30 years, the last time they were held accountable, the last time we asked, are you in the mainstream, was 30 years ago. And more recently, justices don't tend to change a lot when they're on the Supreme Court. And so the answer is probably no. They're probably not in the mainstream anymore. So I find ways to try to ascertain and suss out and connect justices to the constitutional mainstream, which really is a reflection of public preferences, to be desirable in judging. I generally am just not a fan of ideological extremism, whether it's on the right or left.
There used to be a connection between public approval or public opinion on a judicial nominee and the likelihood that a senator would cast a yay vote for that individual. We've subsequently learned that that's still true, but it's only true with the caveat, which is that if public opinion comes in conflict with the opinion of the party elites in the Senate, that the senator yields to the party elites as opposed to public opinion. And so to my mind, it's linking a better linkage between what the public wants and then the representatives who are there, who are supposedly acting as this intermediary to provide the advice and consent. And so the ideological or the partisan split that you mentioned is true, but the critical part with it is it's if you classify the leaners. And so if you break it down and say independent versus Republican versus Democrat, the biggest category in America is independent. And so those folks are not getting representation, right? So those folks, you're pushing them into one side or the other, and both of the sides are polarized in that way. So it's not terribly surprising then that the process that involves senators from those two parties without sort of a middle ground produces nominees, produces justices who reflect that partisan ideology as opposed to the public. And so I don't disagree with anything that Paul said about that process and about sort of what should be part of the interview process, if you will. But again, sort of consistent with my polarization argument is that that you, again, taking that big step back, which is like, why are we here in the first place? And is there something that's kind of the base cause of it? And I think it's that disconnect between what the people want and then what their representatives are ultimately delivering for them.
Good evening. My name is Garrett Harrelson. I work at staff here at Jacksonville State University. First of all, thank y'all for coming out and speaking tonight. It's been a thoroughly enjoyable lecture. My question pertains to, I think, more of the root cause of a lot of the woes that you've both discussed in your arguments. And it looks more at not as how the institution of the Supreme Court is built by the framers, but more of what has become of the selection process for the justices. Since the confirmation prevents, it kind of provides a snowball effect to where, you have judges who are confirmed, you have the the Chief Justice who becomes the most senior member of the court, and that directly impacts what cases are heard, and what we as the public see as the outcome of the court. My question to you is, do you think that rather than looking at the court for reforms, at least for how the judges operate within the court, do we need to instead look at the congressional side and how these justices are appointed or selected through the advice and consent process? And if so, what suggestions would you provide for areas of reform?
Yeah, I agree with you completely. I think that there is, the observables that we see are a function of what's going into the system, and where things are broken is with that appointment system. Used to 60 votes used to sort of be the threshold that you needed to clear, and if you went back and reran history, reran the confirmation of Clarence Thomas in the current regime under the current Senate rules, he wouldn't be a justice, right? And so I think having that higher threshold potentially produces some of that moderation, right? So the idea that you're not looking at what is the preference of the 50th member of the Senate, but rather you need to look at the 60th instead in order to get the votes to get over that threshold. That's going to inherently have a moderating effect on who's going to be able to get confirmed. So yeah, I think that's one potential step is to reinstitute the filibuster, the 60 vote threshold for being able to become a justice. That's just off the top. But, yeah.
Yeah, I completely agree. Bring the filibuster back leads to moderation. I would also add two more aspects to that, which is every nominee gets an up or down vote like we used to do. And then lastly, we need to stop the very recent practice of allowing nominees to dodge questions. And so I want to be clear, Supreme Court nominees have throughout American history refused to answer certain questions, but starting with the nomination of Neil Gorsuch, that was the first time the chair of the Senate Judiciary Committee basically gave them permission to not answer difficult questions during their confirmation hearings. That created a new trend in which nominees say very little of value at the hearings on controversial matters of constitutional law. And so it's always been that they've dodged a little, but now dodging is the norm. And so this is why I have a hard time defending the confirmation hearings as a valuable part of the process, because if nominees aren't going to say anything, then we're just doing something performative.
And the other thing is it used to be a value, I mean, not just a value just to learn about it, but votes of senators, at least in committee, were influenced by how forthcoming or not forthcoming someone was. And the inputs that go into whether a senator is going to vote yay or nay at this point, you can almost perfectly predict it with one thing and one thing alone, which is partisan agreement with the president. It was not always that way. If you go back and look at the confirmation votes for Ruth Bader Ginsburg, for Antonin Scalia, two justices who are not moderate in any way, shape, or form, there are lots of senators crossing over and voting in favor of those individuals. And so a deficit, being ideologically opposed to somebody was not a sufficient condition to cast a vote against them. And so that's, again, sort of the broader context of polarization that's going on. But the system, used to work reasonably well.
Works better.
Yeah.
Hi, my name is Jenna. I teach biology here. Thank you so much for being here with us and coming to Jacksonville and to Jack State. My question has to do with money, and it's an ethical question. And if you have a system like our judiciary branch without term limits, how do you make sure that the use of money is ethical throughout the process? And how do you temper the influence of money and moneyed interests on the court?
So the code of, I think a code of ethics that makes crystal clear what you can and cannot do as a justice would be an enforceable code of ethics, would be a massive step in that direction. And more transparency about the work that justices are doing, more transparency about who they're seeing, who's paying for things. That's sort of, we have a solution. I mean, we apply that solution to lower court judges who are exact same in terms of their constitutional position, Article 3 lifetime appointments. And so it's not super clear why we can't do that to the Supreme Court.
Yeah, there's also some other reforms that would address some of the money issues in the legal system. Particularly, there's mechanisms by which interest groups can participate in litigation, and they've figured out how to evade the Supreme Court, and this is true of the entire federal court system. These really poorly written disclosure rules, and so if you're a judge, you see this massive lobbying effort on behalf of a party in the Supreme Court, and they can follow the rules and you believe that they're all independent, but in reality, they're this very tangled network that they're each other's lawyers and all of these. There's some financing going on with the entities, and really, it's more problematic than you might think. So much so that the Federal Judicial Conference was proposing some very modest rule changes to this, and they quietly peeled them back after a substantial lobbying effort by very, very moneyed interest groups that were trying to fight.
Bobby asks, how do you think the selection process should change? It seems you believe the current process is biased. Is your issue simply that not all presidents get to appoint?
I think that it would be more desirable to have a closer reflection between the elected president and the Supreme Court. So the haphazardness, in other words. So generally speaking, Supreme Court justices leave the bench through one of two ways. They either die while they're in active service or they retire. And increasingly, they're engaging in something called strategic retirement, which is basically what happens when, say, you have a Democratic Supreme Court justice and there's a Democrat in the White House. You retire because that lets the Democratic president appoint your successor, which furthers your legacy, right? So basically, the process is being gamed. And some of the recent deaths in office are also attributable to strategic retirement plus poor health. And so the selection process, the means by which seats are vacated, they're all kind of wrapped together as a very quirky process that can be exploited. And so I would prefer some level of regularity to limit. It's not going to fix everything, but it might limit some of the means by which the process of a seat opening up and a subsequent appointment has basically become a political game.
It's not just that it can be exploited. It's also subject to all the things that are broken in our brains with how we make decisions, because justices are ultimately people too. And so insights from our friends in economics and prospect theory talk about how you differentially weigh guaranteed losses versus certain wins, things like that. And so if you apply that approach to looking at retirements, it makes a lot more sense that if a justice is in a situation where it's favorable conditions, they're unlikely to want to parachute out in those conditions because they're discounting the future, right? They know that they're giving up potential to be on the court and continue to have an impact and do something that they know, do something that they love. and they're willing to roll the dice that the conditions will continue to be favorable year after year after year. And so the complication is not just that you have opportunity for gamesmanship, but the balance in the gamesmanship depends upon us kind of rising above things that we know are more or less broken with our brains, which is asking a lot, even of Supreme Court justices. So.
Lee Matthews, a member of the community here, asks, you mentioned the process of the approval of judges needs reform. What reforms would you suggest the approval process happen in Congress?
Yeah, so I want to go back to what we were talking about a few minutes ago, and the idea of every nominee getting an up or down vote, going back to having a filibuster. And so the idea of a filibuster is that it, in essence, requires a 60-vote threshold for Supreme Court justices. And so it acts as a moderating force on the president, right? The president knows, I need to pick up that 60th vote. That vote's probably not a member of my political party, even if my party controls the Senate. And so we had some historical ways to moderate the Supreme Court, right? They're all out the window now. And this change to the Supreme Court that's led to the ideological extremism, it is very new, right? This is all over the last 10 years. And this is the consequences when rules and norms are violated, right? So there aren't many guardrails left in terms of the appointment of a Supreme Court justice.
Yeah, there are none. And that's what's made the confirmation. That's why confirmation hearings are not much going on at that point, because you just need to count heads and then go ahead and do the vote.
Our last question comes from a student here, Kai Mosley. He asks, if the court were expanded and broken into, say, 5 justice panels, why would it encourage moderation when any panel would only need 3 of one side to maintain a decision? That likelihood of a random lottery picking 3 justices of one leaning seems good enough for a set of justices to roll the dice on an ideological decision.
Yeah, it's a fantastic question. So my expectation would be that, and maybe I'm asking too much, would be that the justices would self-moderate under the idea that an ideological extreme decision is perhaps likely to be reversed by a future court, right? So it's sort of leveraging a willingness of Supreme Court justices to engage in modesty. And perhaps that's where I'm Pollyanna, because it is also important to recognize that Supreme Court justices really are not normal people. And let me give you one example having to do with what we were just talking about, which is their retirement. So I would argue, and I think I'm right on this, that most of you in this room look forward to retiring, and you look forward to having free time to spend with your friends and family and pursue your hobbies. And in fact, we very much, as Americans, plan our lives that way, right? We put money into retirement accounts and we look forward to these things. Supreme Court justices do not behave that way. They look forward to remaining in power. And this is why they tend to stay on the bench well past the age in which they can very, very comfortably retire. And in some instances, stay on the bench so long that about half of Supreme Court justices in American history have died while actively on the bench. So this is like a very interesting thing to wrap our heads around, and it probably has a lot to do with ego.
You're absolutely right. It's the same retirement incentives that exist for Supreme Court justices also exist for lower court judges, so circuit court judges, district court judges. And if you look at their behavior in the year in which they become pension eligible, they satisfy the rule of 80, that district court judges retire at a very, very high rate. Circuit court judges retire at a slightly higher rate, and there's essentially no effect at all on Supreme Court justices. So the cue that, okay, now I can retire and get my salary for the rest of my life, which is the setup for the retirement scheme, has no impact on them. What's the difference between a district court judge, a circuit judge, and a Supreme Court justice? Power, right? And so it's the amount of authority, it's the amount of spotlight, the prestige that's associated with the position. So in that regard, they definitely prioritize power and have, you could also argue they're just super conscientious. They really want to, be involved in government or something like that. But on all the other ways, they're just like you and me, Paul. So personalities, oldness.
Well, Ryan, Paul, thank you for joining us. Thank you for this conversation. And thank you to all of you here in house and online for continuing to think more deeply and learn more about a fundamental institution of our government. Thank you all.